Good afternoon, everyone. We are here celebrating Data Privacy Day, which is celebrated by the complete data privacy community on 28th January 2022. What we are planning to have today is a conversation around trends and updates with respect to privacy that we experienced last year. So, what will be the topic that we'll discuss is 2021 data privacy, what exactly happened. We will also have a look at India privacy landscape. A lot of things happened last year in India data privacy area, so we'll have a look at that. We'll see what we can expect in the area of data privacy in 2022, and we'll also talk about briefly about what next steps organization can take with respect to data privacy and security. Moving forward, 2021, what exactly we are expecting? So the last 2 years, we have seen extraordinary changes and challenges in the world, impacting every aspect of our lives. Majority of the changes has been with respect to the pandemic that we have seen, or with respect to the turmoil that we have seen with geological issues that happen. However, considering the ever exciting new technologies and innovations around data, we should certainly expect increasing new opportunities, risks, and trends, and hence vulnerabilities also with respect to 2022 in data privacy. 2021 has been an increasing and interesting year for data privacy. It is the year that all the major tech companies started talking about the language of privacy, with Apple leading the pack. Second came Google. Lagging way behind was Facebook with its whistleblower uniting the Democrats and Republicans in US in calling for regulation around the Facebook. In 2021, we saw there were a lot of things happening in the world. However, still data privacy prevailed and we saw a lot of new regulations. So we'll see each of the area what exactly happened in 2021. So there were as I mentioned earlier, there were too many events happening took center stage in 2021. However, we saw the upward trend in data privacy regulations. Uh, there were many countries, there were many regulations that were passed last year. Let's start with USA. A statistics has come up a couple of months back about USA. Around 30 US states introduced more than 160 consumer privacy related bills in 2021 in United States. A lot of these bills are in scope, focusing only on one area of data privacy, biometric information, genetic information, AI, geolocation data. However, there are 23 states introduced a total of 34 comprehensive bill on the lines of European GDPR. Out of these 23 states, only two states, Virginia and Colorado, passed their data privacy laws in 2021. Virginia Consumer Data Protection Act, signed into law in March 2021, followed very shortly by Colorado Privacy Act, which became law on July 6th. These laws will become effective in 2023. So, organization has around 2 years time period to be compliant with these two laws. Uh, the neighboring area, Brazil LGPD, also went and became a law. So we also have a law in Brazil now. The most stringent one and more talked about recently is China Personal Information Protection Law, which came into force in November 1, 2021, only after 3 months after its approval by the National People's Congress. So only 3 months the organization got to be compliant with China people. It is currently talk of the town due to its stringent data transfer requirements, rules and regulations, as well as stringent localization requirements and some very interesting obligations on organizations which China terms as personal information handlers. Uh, in Europe, when we come to Europe, we already have GDPR. However, we have seen Brexit happening and UK coming out of European Union, European Economic Area. So UK now has its own GDPR, UK General Data Protection Regulation. It is heavily based on EU GDPR, but there will be some things which UK will bring in the flavor with their own regulation. But we saw now we also have one regulation in European area along with the EU GDPR. Very interestingly, we have seen some information, some things in Middle East as well. So as part of the 50th anniversary, United Arab Emirates issued a set of legal reforms. So they decided that they will have set of 50 legal reforms. Data privacy is one of them. So uh, for these legal reforms, what happened is they brought their protection of personal data law. The UAE data protection law was issued on 26 September 2021. This law became effective this January, 2nd January 2022. Again, the neighbor of UAE, Saudi Arabia, the Kingdom of Saudi Arabia published their personal data protection law, which went unpublished on 24 September 2021. This law will enter into force couple of months afterwards, March 23, 2022. So they have around 6-7 months to comply with the regulation. This regulation talks again about collection, processing, and the use of personal data within the Saudi Arabian kingdom. So mostly we'll see there are new privacy regulations coming, and then we have a few more privacy regulations. So out of 23 privacy states tabling their privacy regulations, or two, but then there are many other countries or many other states which are still line up with their privacy regulation, which we will see in 2022 and 2023, this years. More importantly, what happens is many organizations come to us and talk about that nowadays companies don't work in single right? They are MNCs, they cater to multiple clients, and majority of the issues are relating to how we can comply with these many regulations. So I'm not only, working with my clients, which is in India, but I'm also working with my clients who are in Europe, maybe in Germany, Ireland. They are also in US. And now when you say US, every state will have every other regulation, right? So organization always face this problem with respect to how to handle and how to look at the compliances. The more important thing or the suggestion that we provide to the organization in this aspect is, even though regulation, countries, states have their own ethics, integrity, have their own cultural points which heavily influence the regulations, but then there are principles which are common. Regulations, uh, on the basis of principle, they talk a lot of similar things, or they request a lot of things, similar things. For example, every regulation will say that you will have to process the data lawfully. Every regulation will say you need to, keep the data accurately. Every regulation will say you need to provide security to the data. Every regulation will say that you need to, keep the data only for a certain time period. Uh, so you have certain principles which are common. Most of the regulations will require to incorporate privacy by design. Most of the regulations will say that you need to conduct impact assessment or risk assessment for your high risk information. Uh, so certain things which will be common with respect to regulation. Every regulation will say you need to have a breach response plan. However, certain things will be different, like uh, what is the age of the child, right? It will be different for each of the regulations. Somebody will say 13, somebody will say 15, somebody will say 16, somebody will say 18. So those are the nuances which you need to capture. uh, some rights will be different. So one right or regulation ask for, the other regulation will not ask for. So that is a different flavor. So you will have to track these outliers or these differences, but then there will be certain things which will be common. So you have to keep track of that. So if an organization keeps track of whatever is common for the regulation, or whatever I am going for the regulation, and what is the nuances, what is the outlier or specific thing that regulation requires with respect to maybe age of child, right of data subject, breach notification period, data localization or transfer requirements. These are certain things which will be very different for different regulation. And if you keep track of that, your life will be much easier in that aspect. And now, when I'm talking about organization and some outliers, we were talking about the data transfer requirement. So the major aspect happened in 2021 was also respect to cross-border transfer of data. So a major aspect was in European Union, even after GDPR became effective in 2016. European Union were using the old SCCs from 2010 for the data transfer, and they were not renewed. So in 2021, European Commission finally issued new standard contractual clauses for transferring data outside of European Union in June 2021. Now, more importantly, the criteria that they gave is very interesting. So any new business contract taking place after September 27, 2021 must use the new standard contractual clauses. The organization which already have old SCCs with their service providers or clients, the old SCCs, they have time till December 27, 2022 to adopt to the new SCCs. So if you are having a new contract with a new vendor, use the new SCCs. If you already have a contract, so you have existing client and you are using the SCCs, then you have time till December 27, 2022. So this year end, you have time till that to adopt to the new SCCs. So now this is for EU SCCs, very mammoth task for some of the clients or organizations. For new contracts, it is fine, but completely looking at the older contracts, some clients have service providers or third-party vendors in tens, some clients have in hundreds, some clients have in thousands. So very interesting, very mammoth task for them to take. Apart from that, there were two major decisions were taken at the EU side again. European Commission adopted two positive adequacy decisions in favor of UK. So now we discussed earlier that UK moved out of European Union because of Brexit, right? So now what happened to the data transfer to UK from Europe? Because now it is not part of European Union. So there were two adequacy decisions that were taken in June 2021 that made United Kingdom is now adequate country. So no extra transfer mechanism is required when you are transferring your data from European Union to UK or vice versa. Additionally, in December, there was new adequacy decision taken in favor of South Korea. So now South Korea is also added in the list of adequate country. It was the decision and discussion was going on for past 2 years. It started, I guess, in 2020, 2019, 2020, 2021. So basically 2-3 years the discussion was going on, and finally in December 2021 it was passed, and now South Korea is part of the adequate list. China people, which came into effect November 2021, it has its own data transfer requirements and various different things are there listed. Cyberspace Administrator of China, CAC, which is the authority of China, released draft security review measures for data transfer. For public comments on 29 October 2021, 1 month was given for the public comments. There are three cybersecurity regulations in China right now. Cybersecurity law passed in June 2017, data security law passed in September 2021, and PIPL, Personal Information Protection Law, passed in November 2021, which basically define all the cybersecurity, info security, and data privacy security related regulations over here. All the three laws impose some restriction on data transfer and require government security review in certain cases. So there are certain things that need to be taken care of. One of the things are any operator of critical information infrastructure. So they have mentioned certain operators or certain services that you do as critical information infrastructure, CII. You need to do a security review when you're transferring the data. Also, any entity transferring important data outside China, again, the regulations are pending. What is important data, how much, what kind of security review, and everything, regulations will come very soon. Also, personal information handlers, any organization which is handling personal information of 1 million individuals and above, you need to do security review before transferring the data. Or entity transferring more than 1 lakh of personal data or sensitive data of 10K individuals or 10,000 individuals outside of China, you need to have a government security review, and you need to have security review done before you are transferring the data. More regulations, more stringent requirements, more guidelines will come up. China is still working on it, but we are anticipating something on this line. Organizations are still scrambling and still trying to understand what exactly they are supposed to do in this aspect. Okay, COVID pandemic continued. It started 2021, 2020. It went into 2021, and in 2022 we are seeing the new variant, Omicron, however we pronounce it. Okay, remote work continued. We tried going back to offices, but still now we are back to our home front, working from home. Saw a lot of things over here, because when you were working from offices, you have your security, you know how you're processing your data is in secure environment, restricted environment. But now when people are working from home, uh, we don't know what kind of devices they are using, how the security is provided, how the data is getting shared. So remote work has posed a lot of issues with respect to data privacy. There are a lot of guidances coming up. Uh, Companies are not pretty sure about what exactly they're supposed to do. So 2021 also saw a lot of high-end things with respect to data privacy and security, and guidances also. Specifically, European Union came up with their own guidance around it. Singapore came up with their own guidance around it. Canada talked about it a lot in that aspect. Even Australia talked about it in remote work scenario, what needs to be done. Alternatively, on another front, organizers started collecting data for COVID-19 to understand what is the health status of the employees. More importantly, not only the employees, but information started getting collected about the relatives of the employees. More importantly, I think the organizations struggle to understand that when they are collecting data for COVID, they also need to understand and comply with the regulation of data privacy. And there the fault started, because the information now they are collecting, they are having very sensitive information, because all the regulations, even though they don't tag data as sensitive or a special category of high risk, all of the organization, but they consider health data about a person a very high risk data, right? Uh, GDPR says it is a high risk information, sensitive information. India specifically says that health data is high risk information. Along with that, biometric information, identifiers were collected, and a lot of information was collected which was not looked after with data privacy, and posed a great data privacy scare in that sense. So because of COVID, and currently right now organizations have come to some semblance what to be done with this data. But more importantly, this data still lies not in the central repository of the organization, but data also is available with a lot of individual employees and lot of local machines of the employees, and the organizers still don't know how to handle this information. More importantly, for how long this data will be retained, and how this data need to be disposed, and what should be done about this data after the pandemic gets over, and if the need is not there about the data. So a lot of things are still in the gray area related to data privacy and COVID-19 here that we talk about. When we look at all the above aspects, there are new regulations coming up, data transfer mechanisms are there, and then there are COVID-19 scare and data collection that is happening rampant in the case, and even the security is lagging due to work from home scenarios, right? So what happened about enforcement in 2021? 2020, basically owing to COVID-19, there was lull in activity. So not many organizations were fined in 2020. Very limited enforcement, majorly owing to the pandemic that has happened. But 2021 featured a very upward trend in enforcements all around. GDPR again leading the pack over here. The front runner enforcement was related to Amazon 746 million euro fine in Luxembourg. Uh, Most importantly, this 746 million euro fine was related to how the data was collected. 10K people actually filed a complaint against Amazon in way back in 2018, and this complaint was related to the advertisement targeting system. The complaint was related to Amazon not taking proper consent from the people before providing targeted advertisement. And these 10K people were not only with respect to Amazon, but they were also with respect to the customers of Alexa. which is a device provided by Amazon. They were fined 746 million. This is currently disputed because Amazon has gone back and specified that they think that this is not correct way. Discussion is still going on, but this fine is the major fine that was charged by a European authority, which was Luxembourg. The second foremost talked about decision or enforcement in 2021 was against WhatsApp. This was a 250-page decision by Ireland, IDPA, and this is related to cross-border data transfer. So the issue here was there were two things that were notified by Irish DPA. They mentioned that one thing, WhatsApp didn't inform the data subjects or individuals about their data sharing practices. So WhatsApp is faltering on Article 12, 13, and 14, which talks about right to information of the individual, about letting them know. The second thing that they mentioned is they are faltering on the data sharing or data transfer practices because the information is going to Facebook and other varied affiliated companies of WhatsApp without proper channels or proper basis of processing. So these two areas were taken into consideration, and a fine was levied on WhatsApp over here. Decision is pending on Facebook, very interestingly, as well as a case was sent to Australian court from the CJEU. So there are many enforcement that happened, and there were a lot of enforcement around digital marketing that happened in GDPR as well as Australia uh, and Canada. So there were many enforcements that were there, and we are thinking about that this trend will continue and increase in 2022 and even in 23. Looking at, we now have US 3 regulations, more regulations will come up. India, we are looking at the law, we are looking at the act right now, which will soon become the law. So this count, we are anticipating it will increase. We are open for questions. Anybody has any question over here, or anybody wants to put forth their comments about it? We are open for the audience right now. Varsha, over to you.
Yes, thank you, Swati. I like to know if everyone has any questions, can raise their hands, and if so that we can answer the questions.
Okay, great. If then we can move to the next area, that is India privacy landscape.
Yes, yes, Swati.
Sure. Thank you, Varsha. So let's look at the India privacy landscape, what currently is the scenario in India. So as we all know, India does not have a comprehensive privacy regulation right now. However, we talk about privacy in various areas, various sections. We have Information Technology Act 2000, which was amended in 2008. So we have two sections which are specifically about privacy and personal data. We have section 43A and we have section 72. Section 43A specifically talks about SPDI, Sensitive Personal Data Information Rules, which gives about steps organization has to take to comply with privacy. And SPDI rules also define what data is called as sensitive personal data. So financial information, your passwords, health information is termed as sensitive data, and then you have to provide proper notice when you are processing sensitive information. You need to have grievance mechanism, you need to take proper consent from the individual. So SPDI rules specify what an organization need to do when they are processing sensitive or personal data. Along with that, we have section 72, which talks about breaches of personal data. It mentions that organization has to have reasonable and proper security practices when they are processing personal data of an individual. And reasonable security practices are dependent on organization to organization, dependent on what kind of data you're processing. So reasonable practices may differ from a school to a bank to an insurance agency to an airlines to telecommunication. So it depends whatever your organization is, what kind of information you're processing. Dependent on that, you will decide the reasonable security practices that are required by you. So we have two sections, Section 43A, Section 72 in IT Act 2000, amended in 2008. Along with that, we have right to privacy, which was introduced uh, in the Article 21 of our Constitution. So we don't have a separate right of privacy, but we have right to privacy included in right to life and personal liberty guaranteed under Article 21 after the Puttaswamy judgment. This was in 2017. This was done. Earlier, right to privacy was not part of our Constitution, but now it is specifically introduced in our Article 21 of the Constitution. Along with that, now we are talking about a comprehensive regulation which has been in discussion since 2018, right? The Personal Data Protection Bill 2018, we see in 2018 version. It was revised in 2019, released on 10 December 2019, introduced key changes. So there were a lot of difference between 2018 version and 2019 version. Post approval by Union Cabinet, the PDPB bill was introduced in the Lok Sabha by the minister that time, Mr. Ravi Shankar Prasad. The draft report on bill was adopted on 22nd November 2021. The bill governs the processing of personal data by government, companies incorporated in India, as well as foreign companies dealing with personal data of individuals in India. Today, we are not going to talk about India PDPB in detail. We had sessions about it. Right now, what we are going to discuss about is the draft report that Joint Parliamentary Committee presented in the Lok Sabha. We will be going to talk about it in brief. So the report that was presented in the Parliament by Chair Mr. P.P. Chaudhary, it was presented on December 16, 2021, last week of the winter session. The report basically contained two parts. Part one consisted of general description and specific 12 recommendations on data protection and privacy. Part two was related to clause by clause examination of the bill. So over the 2 years that the bill was discussed by the Joint Parliamentary Committee over number of numerous meetings, right? They went on clause by clause in the bill and contained totally 81 recommendations, making modifications related to not the statements of the regulation, but also certain additional clauses or removal of certain statements or clauses were suggested in specific to the data protection bill. So let's now look at what were discussed in the bill on the top level. So scope of the law. So personal data protection bill, the JPC recommended that we also need to include non-personal data, including anonymized data in the bill or scope of the bill. So this bill will not only cater to personal data, but bill should also cater to non-personal data. Separate regulations will be, set for that, developed for that, for non-personal data, and same data protection authority which will be, looking at handling of personal data, they will only recommend it to handle non-personal data regulations or non-personal data enforcement or breaches. Second foremost, obviously now we are not only looking at personal data in this sense. So the title of the bill was recommended to change to data protection bill instead of personal data protection bill, right? And the title of the act should be Data Protection Act 2021-2022 whenever the bill gets passed. Implementation of Data Protection Act, the time is given or suggested to be given as 2 years, 24 months for the organization from date of notification. And obviously it will be phase wise implementation. Time period will be given to organization. Guiding principles to handle data breach, there were some recommendations given by the committee for handling data breach. In regulation earlier, there was no time period defined or stated for providing the suggestions. So here it was stated that 72 hours the breaches should be reported to the authority. So DPA should know about the breaches within 72 hours after the organization becomes aware of it. That is the recommendation given by the JPC. More importantly, JPC also suggested that now breaches are not only personal data breaches, but any kind of personal as well as non-personal data breaches has to be included in breach scenario. Organization has to maintain a log of the breaches, personal data as well as non-personal data breaches. So JPC went ahead and given these recommendations. Dependent on the final report, we'll understand if these recommendations were considered or not considered. Processing of personal data of children, there was recommendations around children data processing. Uh, Organization dealing exclusively children's data required to register themselves with the data protection authority. So that is one of the recommendation given. So if you are a school, if you are an educational institute, or you are specifically catering to children, you are a game provider, children's game provider, you need to register yourself with the data protection authority. That is specifically mentioned. Also, organization, this is very interesting, this recommendation that the JPC has given. Organization should inform the child for providing consent again at the date of majority of the child. So 3 months before the child attends its majority, the organization has to take consent again. For example, parents have opened account for a child on Instagram, right? And now the child is 18 years old. Instagram has to go back child now to take the consent to keep the account open. So that is what the recommendation that JPC has given right now. So if the organization already has data of the child and now child is attending the majority, the organization has to take the consent from the child now to continue providing the services to the child. Child's age in India is right now 18 years of age. 18 and below is considered as child in India. Social media platforms, this is very interesting again, along with personal data of children. Social media platform, to be allowed to be operated in India, the parent company has to have office in India. So you have to have an office in India to provide your services specifically in India, and this is related to social platforms, or earlier they used to call it as social media intermediaries. Also, very interesting suggestion that was given is if a social media platform or social media company is ensuring that what content should be seen or what content should not be placed on their platform, they should be treated as social media platforms and not as intermediaries or processors. So their liabilities will be on a higher side over here as defined. Also, requirement which was suggested is the blue tick guys or the verification account, currently which is only for celebrities or some known people. The verification can be requested by any person, and social media platform has to agree to the request if proper identification is provided to the company. So anybody can go to the social media platform and request to verify our accounts with them after providing proper identification and verification criteria. Okay, there was also suggested mechanism to certify digital and IoT devices. What the committee identified is various data collection not only happens with some services or software that is provided by companies, but there are a lot of digital and IoT devices are also there, which are used. You will have smart televisions, you will have Alexas, you will have Siris, correct? So they have identified that there should be a mechanism to certify digital and IoT devices. This is the recommendation given by the JPC, but definitely this will be a separate regulation or separate activity that happens outside of the purview of the Data Protection Act right now. That has to be taken care of separately. Localization of sensitive and critical data. So as we know, our data bill requires certain localization requirements. Sensitive data, one copy has to be there in India, right? And critical personal data has to be there in India. We can't send critical personal data outside. So that is one requirement. Interestingly, we don't know what critical personal data is as of now. Very soon we may know about it, but right now we are unaware about it. JPC has gone ahead one step and said government also has to ensure that all the backdated sensitive personal data and critical personal data which is outside of India comes back to India as per the localization requirements. So any data which has been sent before the notification date by the organization has to come back to India as per the localization requirement. And that was interesting regulation, interesting recommendation that has been given by JPC. Looking at it, it is going to be a very mammoth task for government, as well as if government decides to go ahead with it, organizations who are sending this data out, the backdated one. Exemption of state agency, JPC does not have a very solid recommendation over here to the government. However, it says that specified procedures should be followed fairly and reasonably. That is one recommendation that is given by the committee over here about exemption. So exemption to state agencies remain. The only thing that remains is whenever you are doing it, follow a reasonable and fair procedure is what the recommendation has been given by the JPC. Data portability, very interesting. And if a government approves this one, this will be again a problematic or additional work for the organization. So data portability basically says, if you don't know about it, data portability basically says organization has to provide the data that they hold about an individual in machine readable format to the individual or any other organization. So in CLS, XLS, CSV, XML format, you need to provide the data to individual. There are two exceptions to it. One is trade secret. If organization thinks that it will reveal the trade secret of the organization, they can reject this request. And also the second thing is if it is technically not feasible for the organization. Some organization will have data in various places, and providing the data portability requirement to the individual or port the data to other company will be technically not feasible for all the organizations. Many big organizations may be able to do it using technology, but startups or medium organization may not be able to do it. So there were these two exceptions were given. Committee has specified that trade secret has to be removed as an exception. So organization should not be able to reject portability request on the basis of trade secret. A very controversial remark over here, because then you can't say if it is an IP of an organization and they do not want to share it, they will still have to go ahead and share this information if this recommendation is accepted. Uh, pretty problematic for organization. And the second thing is for technical feasibility, they are not asking organization, they're not asking the exception to be removed. However, what is technical feasibility? They want it to be very clarified. What can be considered as technical feasibility? Further regulations and guidelines will be accepted over here in this case with respect to data portability. So these were the recommendations that are specifically given by the JPC. And right now, what is we are expecting is the cabinet or METI is currently preparing a note for the cabinet, which will be tabled in budget session. So upcoming budget session, which will be there in end of February, whenever the parliament will have it. METI, Ministry of Electronics and Electronic Communication, India, are preparing a note around personal data protection bill and the JPC report, and they will be tabling it for the cabinet. So it is kind of a wait and watch scenario with respect to the committee as well as what note is presented to the parliament. And we have to now wait for the budget session to see what is in plan for India. Considering the current scenario and the new regulations that are coming around the world, we have now UAE, Saudi Arabia, US has two, many more will come this year. We have China with new bill, many other regulations are coming. I guess it is high time India should also pass our regulation right now. Okay, we are open for the questions or any inputs or comments if you want to pass. We are open for that. Do we
Yes,
have any
Swati,
questions? Do we have any input from anyone?
we have one
Okay.
raised hand from Mr. Rama Ramesh. Can I ask them to unmute themselves and ask question? Hello, Mr. Rama Ramesh. Am I audible?
Yeah. Uh, Hi, Swati. This is Rama here. I just wanted to
Hi,
know
Rama.
how this entire data privacy was started. Was it because of GDPR that this privacy across the globe has started? Was the origin by the GDPR from the European Union?
Not exactly, Rama. It is not the new one. It has been there for ages now, right? In 1980s or before that, also data privacy was there. There are regulations which dated from 1980s and 88. So data privacy was
Right.
already there. Okay, data privacy was already there in the picture. GDPR brought it into the front line and made it mainstream, right? So data privacy was already there. There were regulations which are there in 2012. Singapore was there. 1985 there was data protection directive was there in the European Union. In 1980s we have OECD, and before that in 1960s we have very conventions around data privacy. So data privacy history is evaluation is there since earliest of 1900 centuries. GDPR brought it into the limelight because of the fines, penalties, guidelines, and enforcement, which is becoming very happening, and that's why now it is mainstream with respect to and whatever the digital innovation and technology that we are seeing right now in the world.
Yeah, I have one more question.
Sure.
Actually, when we implement this information security in an organization like a standard like 27001, there is already control for the privacy, where it says that the privacy will have to be enforced as per the applicable laws and regulations. Now,
Hmm.
other than that, there is other standards also coming up like 27701. So I just wanted to know whether 27001 information security itself is sufficient to cover the privacy as well, or we still need to go with the other ISO standards.
Okay. So 27001 is an information security standard. Okay. And 27701 that you have mentioned is an extension to the information security standard for privacy standard. So
Right.
information security standard covers a part of privacy. It is not completely sufficient. So if you want to be compliant completely with privacy, you need to have ISO 27001, and then on top of that ISO 27701, then you will be considered as compliant with data privacy. However, ISO 27701 gives you a framework of data privacy, but your organization will be driven by the regulation those are there which are applicable to your organization. So if you are catering to European Union people, GDPR applies to you. If you are catering to US, specifically California, CCPA will apply to you, right? If you are into health data, then HIPAA in US will apply to you. So accordingly the applicability happens.
Okay. Thank you, Swati.
Do we have any other question or should we move to the next one?
Thank you, Ms. Rama. Uh, I would like to ask you to mute yourself. Thank you.
Okay, everyone. Moving on to the next section, which is related to what we can expect from 2022 with respect to data privacy regulations. So 2022, we can again see a tsunami of new laws and regulations in 2022. For years, USA was talking about a need for comprehensive federal privacy law. Despite the consensus around it, I am actually not expecting it to be passed in 2022. However, there will be some flurry of activities around it. So even though they have US states laws, they also are talking about a federal level law. and the discussion has happened. Both the parties are agreeing to it. A lot of discussion happening around it. May not pass this year. They will require a couple of more years for it, but some activities, some traction over there will be there, certainly. Apart from Virginia and Colorado that we have seen last year, right? We have 21 remaining states which are talking about a comprehensive regulation, and furthermore 36 states which are talking about sector specific regulations, right? So we'll see certain regulations to be uh, passed over there, or some more information about it over there. I suggest keeping a close watch on certain privacy regulations. So you can see states of Maryland, New Jersey, Ohio, Florida, Oklahoma, and Alaska. They are ahead in the race with respect to the state-wise regulation. We can see at least couple of more states from this list to have passed their regulation in 2022. Apart from that, we are talking about India Personal Data Protection Bill. We should have this regulation as soon as possible. We need it right now. It is need of the hour that we have. Apart from that, Australia already have their privacy regulation, Australia Privacy Act. They are currently revising it. They have requested for consultation and comment from the public and the privacy community. Switzerland has FADP, so they are revising the FADP right now, and it will be on the basis of GDPR. So they are bringing new sections or clauses in Switzerland FADP. Apart from that, we are also seeing Hong Kong will also already have revised ordinance, and they have amended their amendment 2021, but they will also bring some regulations over there. Along with that, Singapore will also bring their regulations in it. Implementation phase, whichever regulation that we have seen in 2021, being it UAE, Saudi Arabia, Virginia CDPA or Colorado CPA, even California has CPRA. These will be in implementation phase. So many organizations will need to adhere to these regulations and be compliant with that, along with their compliance with GDPR. More importantly, organizations ask us about we are compliant with GDPR. What I need to do with respect to the other regulation, or how I should handle with respect to the regulation. The answer is the same. GDPR normally covers because it is best practices, and the regulation more or less right now are tending towards GDPR, and they are basing their regulations on GDPR. They are entering certain things which are flavorful to their culture. So it is basically 80-20 or 70-30 scenario, where if you are already compliant with GDPR, you tend to have 70% controls covered. But then there are 30% controls which are specific to the regulation. So UAE will have some certain specific things with respect to their area, or Saudi Arabia will have their own one. So you need to identify what is that 30% lag that is there with respect to the specific extra regulation that will do, and you need to implement that. More importantly, certain organizations also request or ask about how can have a privacy policy for the organization when we have multiple jurisdiction or multiple geos to handle, because UAE will ask something else, India will ask something else, US will ask something else. How many policies I have to prepare? Our answer is same. You have to prepare only one privacy policy for your organization. You have to look at the common practices that you will follow, and which is bound to your organization, and then you have to specify your processes. The processes will be different for your geography. So if your office is in India, you will have some different processes over there dependent on what is applicable. If you have office in US, your process will be different dependent on your location, but your main policy will say the same thing, that I'm going to conduct or I'm going to have this step. But then how the breach will be reported to a US authority will be different than how the breach will be reported to a EU authority, to Ireland, or how the breach will be reported to Singapore PDPC, the privacy committee over there, a commission over there. So those way you have to handle common controls. As I say, you need to have common controls, and then the outliers when you are looking at multiple regulations right now, and that we are going to look at very soon in upcoming time. The next group is guidelines for existing regulations. So what happened is the regulations have been defined by the authorities, and then there were various questions around it. So okay, you have said do this, how can I do this? You said take consent, how can I take consent? You said okay, it is in legitimate interest, but how can I do that? You said okay, localization is like this, but what can I do with localization? Or when you say transfer, you have to use SCC, but what exactly is transfer, right? There were so many questions around it, and there are various guidances which are upcoming. There have been a slew of guidances in 2021 also, but in 22 we are anticipating a lot many. I just looked at two areas. China, majorly guidance related to localization and data transfer requirements. So there will be regulations, there will be guidance, what the organization can do, cannot do, should do, whom to contact, when to contact. We will see a influx of guidances over there. Along with that, EDPB very religiously and regularly provide the status of the guidances. Right now, a guidance on assessment of certification criteria. So Article 40 talks about having certification mechanism for an organization to comply with GDPR. So EDPB is currently working on a guidelines on assessment of certification criteria. So that is expected to be released in 22. Guidelines on the right of access will be accepted to release very soon. Later on, cookie consent, how the consent to be taken, so that is there. Guidelines on example regarding personal data breach notification, how to notify personal data breaches, when to notify, what to notify. So some guidelines on examples, because many organizations come to us and say, hey Swati, we have sent personal data to my two contacts. Do I need to inform the regulatory authority or not? Or maybe my file or my laptop was stolen and it had personal data. Do I need to inform the regulatory authority or not? So right now what EDPB is doing is preparing guideline on examples in what condition you can uh, notify the regulatory authority, and what condition you can keep a log to yourself but no need to notify the regulatory authority. So currently they are preparing that. Guidelines on research, any kind of scientific medical research an organization doing, uh, a proper guideline is coming up. Currently it is in consultation mode. A lot of comments are requested by the EDPB over here, and a guideline will soon come up when an organization is completely processing their data for scientific or archival purposes or research purposes specifically with respect to their business. We'll soon see guideline on children's data. We have seen children's code of conduct in ICO. ICO is Information Commissioner's Office UK. So in 2021, they released code of conduct for children's data. So any organization processing children data, they have a code of conduct, but that is for UK. And as now UK is out of European Union, European Data Protection Board is coming up with their own guideline of children's data, soon to be published and released this year. So we can see this guideline to be released and we will know. Apart from that, we can see also some guidelines around artificial intelligence and machine learning. We will see some guidelines around automated decision making and profiling even. So those are anticipated in 2022 or 23 very soon. Moving on, big tech and privacy. So privacy enforcements are there, taking the leaf out of 21. Expect the regulators to step up the enforcement in 22. The primary focus will be issues related to children's data processing, use of artificial intelligence, use of health and financial information, and also digital marketing. Digital marketing, advertisement tech or ad tech is not going out of fashion anytime soon. Neither are quite privacy questions arising from them. In 22, expect ad tech and marketing ecosystem to try and solve the puzzle of digital marketing regulations. So big tech and privacy, we will see a lot of over here. Along with that, we will see certain things happening at the level of artificial intelligence. So Cyberspace Administrator China, CAC, has released draft guidance regulation to use around algorithmic recommender system, that is for AI In 22, EU is also talking about AI regulation, which is based on concept from the field of product liability. So EU is also thinking about bringing a regulation around AI, artificial intelligence. USA states, the 38 states that I mentioned earlier, which are talking about 160 regulations. Some of the regulations are around artificial intelligence and AI and machine learning. So if we see, we will have specific regulations around how the organizations process not only personal data, but process data for AI and machine learning. California Assembly is specifically discussing Automated Decision System Accountability Act, uh, which is tabled, and several different bills. So Automated Decision Making and Systems Accountability Act specifically talks about AI, machine learning, and automated decision that are made dependent on whatever analytics is done for the data. Importantly and interestingly, big techs, the companies, Apples, Googles, Facebooks, uh, Amazons of the world, they have our data, and how they're processing the data is more important. How they're sharing the data, how the personal data is, processed, purpose limitation is taken care of, how the data is retained for what they're using is a query, and a flurry of activities will happen over here. You will see some enforcements for the big companies. You will see some stringent guidelines somewhere. Some privacy regulations will not take care of your big tech issues, but some supporting regulations we will see around AI and machine learning in various areas. Uh, Not anticipating anything right now in 2022 for AI regulations, but very soon, 23, 24, we'll see some regulations, supporting regulations in big tech and privacy here. So any question related to this section? Any question, any suggestion, any inputs from anyone? Great, then let's move on to the last area, last section that we'll talk about is organization next step, what they can do and what they cannot do, how they can work ahead with it, right? Many of the organizations ask us about it. So when you look at privacy regulations and when you look at supporting guidances and guidelines and what we are not supposed to do, there are three areas that we look at. So if you want to understand the regulation and law, majorly there are three pillars that you look at. First pillar is principles of privacy. The second is rights of data subjects. And third is obligations or responsibilities of an organization. So when you say privacy principles, those are foundational principles. Those are requested by the regulation. For example, you have to process the data lawfully, or you have to keep the data accurate, or you have to keep the data secure, or you have to retain the data for certain time period is what the regulation will tell you. And this is foundational guiding principle for you or for your organization. You have to do it throughout the processing, correct? Then there are second pillar. The second area is rights of data subjects. This is you need to only do it when somebody requests it. So the individual request access, give me the access of my data, then you will respond to it. Or individual says correct my data, or individual says please delete my data, or stop the processing. So anybody requests it, in that time you will be doing the right of data subject. The third area is obligation or responsibility of the organization. For example, when you are, this is specifically event basis, right? When you are employing a third party or a processor, then you need to have some contracts with them. Or when you need to have a data privacy officer in your organization. Or if you are having a new process or you are changing some process in it, you need to conduct a privacy impact assessment. Or when you are developing a new process or you're developing a system, you need to have privacy by design. So this is event specific. So you have three different areas and pillars. And when you read a privacy regulation, you need to look at what are the privacy principle, inherent principle that this regulation wants me to do. What are rights they want me to give to data subjects? And apart from these two things, what are the additional obligations they want me to do? Do they want me to have any contract with the processor? Do they want me to have a data privacy officer in my organization? Do they want me to have PIA or privacy by design in any case? Do they want me to have my office in the country? Do they want me to have a localization requirement, or do they want me to have any data transfer related requirement. So if you decide and if you define that, understanding the regulation becomes easier for the privacy professionals. Also, if you look at any privacy program, it is based on three different areas or three different groups or majors: people related, process related, and technology related. When you say people related, it is not a job of the people who are there in this webinar and me, right? Because personal data is handled and managed by many people in the organization, people need to be aware about what they are supposed to or what they are not supposed to do. So they need to know what is their responsibility. So awareness has to be there with the people. Training has to happen. The training can happen at the time of induction when they join the organization, or regularly. The regularly part you can decide. No regulation tells you that you have to do it annually or 2 yearly or something like that. You decide when do you want to have it, right? So that awareness has to be there. The second thing, processes has to be there. So when we talk about, I need to have a breach management process, or I need to have a, I will conduct PIAs, or I need to have privacy by design, or I will keep the data accurate. But you need to have some SOPs around it or guidelines around it. When you say I am going to keep my data accurate, what do you mean by that, right? For example, I am taking email from people. When you say data accurate, are you authenticating the email, right? You can authenticate the email by verifying the email, click link for verification. Or when somebody gives you your phone number, are you checking it with OTP correction, or you are just taking 0000, correct? So do you have the SOPs and guidelines in place for various activities? So you need to have some processes which can be followed by people over here. Do you have certain rules around it? So children's data, I'm not going to take children's data. So you have some verification mechanism over there and some SOPs over there. So these processes need to be there. So that is second side or group of it. And third thing is technology. Are you going to do everything manually, or do you need to use some tools? For example, you have data subject rights requirement. So are you going to do it, send me the email and I'm going to manage it in my Excel sheet, which is done by certain things? Or are you going to use some data subject right management tools, right? Or are you going to use check the cookie consent manually, or are you going to have cookie consent manager? So there are various tools, and again this is different from organization to organization. Some organization looks at the cost and say, okay, I'm going to go with the technology PETs and implement those. Other organization says, no, I am currently mid-size or small organization, I will still would like to go conservative on this, and I'm going to go manual. But that is dependent on your organization and how you would like to go ahead with it, and your management decision, basically how you are want to budget it. But importantly, whatever controls you placed, organization placed on your privacy program, dependent on these three activities. Awareness, people should know what is privacy, what they're supposed to do, do's and don'ts. Processes, what will you do with every area? Retention, how you will retain the data, how you will delete the data, when you will delete the data, when you will review the data. So you will have some process around it and people know about it. So you process, you made the process, you inform the people, awareness is given, and then you decide, are you want to delete the data manually, or you will have some technology around it, on time period like 12 o'clock dot sharp, delete the data or archive the data. So it is dependent on you guys. So these are the three pillars. More importantly, when you look at these areas, what we suggest is to have privacy frameworks. You can go with the regulation and say, I'm going to go with regulation and implement privacy in the organization, or you can have framework in the organization. Framework is basically gives you standard, a table or chart where it says that I'm going to do 1, 2, 3, 4, 5 things with respect to privacy in my organization. The things that you need to do with respect to the regulation will differ. For example, the framework will say I need to have a breach management process in my organization, correct? Now the regulations will say different things about it. For example, GDPR will say notify in 72 hours. Some other regulation will say give me the awareness within immediately, right? India will say 72 hours you need to inform me. So those parameters will differ from the regulation to regulation, but your process will remain the same. So that is your framework. Organization, go with a lot of different ways. You can have your own framework. You can decide this is the basic framework that I'm going to have, and that will be dependent on the regulation that is affected or applicable to you, or the best practice that you want to follow. So you can have your own framework, and that is set up in your privacy policy. So your privacy policy will define your privacy framework, that this is what I'm going to do. But if you would like to go ahead, so some organization go ahead one step ahead and have industry practices or frameworks in place. One of them is NIST privacy framework, which is US based company, and have their own privacy framework. So you can use that. Or we have Data Security Council of India, which has a data privacy framework. Many organizations also go for that and use that framework also to implement privacy. It gives you idea about what you are supposed to do with respect to privacy if you want to implement. You can also go with standards. So Rama was asking me about ISO standard, right? So we have extension to 27001, ISO 27701 standard, which is for data privacy. You can use that standard to implement data privacy as a framework. Importantly, whichever regulation apply to you, you need to look at those parameters over here and plug it in your framework. Similarly, Bureau of Indian Standards, IS 17428. This is the Indian standard which was published last year. Why I am putting DACI and IS 17428? When India Personal Data Protection Bill becomes Act, right? These two names you may hear as officially by Indian, because we have IS 17428, which is by Bureau of Indian Standards, and DACI is Data Security Council of India. It is an Indian organization, right? So we may hear these names along with ISO 27701, NIST privacy frameworks, or any other privacy frameworks that come into the market that time. So remember these names. We'll just look at briefly what DACI framework says. So you'll get an idea about what exactly you need to cover when you're looking at privacy. So there are 9 areas in the DACI privacy framework. It starts with visibility over personal information. So you need to know where your personal information is. Until unless you don't know personal information, where you're keeping it, where you have your data, you will not know what to do with it. Correct? If you don't know where exactly the data is kept, how will you give it to people when they ask for the data? So you need to know, you need to have visibility over it. Have you kept in your AWS cloud? Have you kept it in Microsoft OneDrive, SharePoint? Is it in local machine somewhere? Where exactly your data is? Second thing is you need to have POR, privacy organization responsibilities. Somebody has to take care of data, correct? So somebody needs to know what privacy has to be implemented. You need to have policies and processes around privacy. That is the third thing. You need to have regulatory compliance and intelligence. Privacy is currently in mainstream. There are a lot of things happening. So you need to have a tab on regulatory compliance, where exactly what is happening. We are working currently in South Korea. Is there any change there? We are working currently in Singapore. Is there any change there? Is there any review happening? New guideline coming? So you have to keep track of there. So you need to ensure that somebody is there. This can be done internally, or you can, subscribe to newsletter, subscribe to some companies. Some companies provide this kind of information, or you can have a consultancy specifically for this activity. You need to have specifically for privacy contract management. So third party processors that you will employ or your client, ensure that you have proper contracts, right? Whenever you are controllers, whenever you are processors, look at your contracts and see if you have data protection clauses in there or not. Privacy monitoring, incident management, you need to have breach identification and notification. So people should know which breaches, which incidents are related to privacy. So they need to understand it. So you need to have some process around monitoring and incident management with respect to data privacy and personal data. Information usage and access. More importantly over here, whenever you are sharing the data with teams, when you are giving access to people, you are giving it only on need to know basis. So again, processor around it, some approval mechanism over here. So this is one area importantly organization need to handle and manage. Along with that, you need to have importantly about important aspect, privacy awareness and training. So people need to be aware about privacy. They need to know what they're supposed to do, what they're not supposed to do. Importantly, do not share your password. Do not send data to anybody who are not supposed to look at the data. Don't take the data home. Okay, don't keep or don't give access to anybody else which is not required. Don't send the email. Or if you're sending financial information over the email, please have it encrypted or password protected. So certain awareness you have to have in your organization or also employees. So you need to have privacy awareness and training sessions over there with your employees. And then most importantly, information security. So you need to have some process around information security. Organization has to identify. So regulations are not going to tell you need to have a 256-bit encryption, or you need to have a 128-bit encryption, or you should go for some hashtags, right? Importantly, what kind of fashion you need to go. So more importantly, you will decide on the basis of what kind of information you are processing. You will decide the information security practices that will follow. So, but you need to have a process around information security over here, and that is most important. So these are the 9 areas or 9 pillars which DSCI DPF data privacy framework talks about, starting from personal information visibility, organization privacy office, some processes around privacy, keep tab on regulatory compliance, which is 4th one, have proper contracts with your third parties and vendors and clients, have incident management process properly, monitor privacy, access controls, need to know basis access to be given. You need to have privacy awareness and training for your people, and also you need to have processes around personal information security. So that is what the DPF framework talks about, and I'm looking when the data protection bill becomes act, this is one of the framework which will be talk of the town very soon. Okay, that's it from our side in today's webinar.